Ready? Exercise number 13, legal matter, start. There may be many good reasons for the authors of the Constitution giving separate treatment to gas and gas works. If one can surmise, it may be that as the industry of gas and gas works was confined to one or two states and was not of all India importance, it was carved out of entry 24 and given a separate entry, as otherwise if a declaration by law was made by Parliament within the meaning of entry 7 or entry 52 of list 1, it would be taken out of the legislative power of states. Be it as it may, the express intention of the Constitution is to treat it in normal times as a state subject, and it is not in the province of this court to ascertain and scrutinize the reasons for doing so. It is suggested that this 53 interpretation would prevent Parliament to make law in respect of gas and gas works during war or other national emergency. Stop, next para. Apart from the relevancy of such a consideration, the apprehension has no justification. For under Article 249, Parliament is enabled to take up for legislation any matter which is specifically enumerated in list 2nd whenever the Council of States resolves by 2/3 majority that such a legislation is necessary or expedient in the national interest. So, too, under Article 250, Parliament can make laws with respect to any of the matters enumerated in the state list. If a proclamation of emergency is in operation, Article 252 authorizes the Parliament to legislate for two or more states. If the houses of the legislatures of those states give their consent to the state course, subject to such emergency of extraordinary powers, the entire industry of gas and gas works is within the exclusive legislative competence of a state. Stop, next para. It is therefore clear that the scheme of harmonious construction suggested on behalf of the state gives full and effective scope of operation for both the entries in their respective fields, while that suggested by learned counsel for the appellant deprives entry 25 of all its content and even makes it redundant. The former interpretation must therefore be accepted in preference to the latter. In this view, gas and gas works are within the exclusive field allotted to the states. Stop, next para. On this interpretation, the argument of the learned Attorney General that under Article 246 of the Constitution, the legislative power of state is subject to that of Parliament ceases 54 to have any force, for the gas industry is outside the legislative field of Parliament and is within the exclusive field of the legislature of the state. We therefore hold that the impugned act was within the legislative competence of the West Bengal legislature and was therefore validly made. Stop. Next para. During the course of hearing, it was brought to our notice that in view of several usury laws and debt relief laws in force in several states, private money lending has almost come to an end and needy borrowers by and large depend on banking institutions for financial facilities. Several unhealthy practices having slowly penetrated into prevalence were pointed out. Banking is an organized institution and most of the banks press into service long-running documents